You're listening to Civic Media. You can tune into any of our live shows on any radio station across the state with the Civic Media app. Find us in your phone's app store and listen anytime, anywhere.
Welcome to Amicus, a law review with Jim Santel, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santel.
This is Amicus, a law review on the broadcast stations of Civic Media. I am, as always, honored and delighted that you have chosen to spend some time of this weekend in discussion, in conversation, in communication with me and my terrific producer, Max, on the major issues of our week, our day, our month, our years together here in the United States of America and on the face of this planet. All of those issues, all of those events, focusing upon justice-related issues, rule of law-related matters, developments inside government and outside of government as well. And boy, do we have a lot of news items and commentary to discuss this weekend. As always, you can be a part of that discussion, that engagement, by sending to Max or to me your question, your inquiry, your observation, your comment about anything on our, as always, aggressive but achievable syllabus. That phone number is 855-752-4842. That number, once again, 855-752-4842. The broadcast stations of Civic Media. Also, you can drop a line, drop a note to us in the chat box, Civic Media. Be a part of our discussion. We will be certain to get to those during the course of our 2-hour program this weekend here on Amicus, a law review. Amicus, as always, taking our name, taking our mission from this Latin term, this legal term that means friend of the court, amicus curiae, hopefully providing you as our friends out there in the community, across partisan divides, across political perspectives, on the things that are going on in our nation, in our state, and in our world, providing information, insight. We spend a lot of time talking about civics on this broadcast, and today will be no exception to that rule as well. Let me tell you a little bit about the things that we've got planned for you this hour and next hour as well. Again, inviting your participation in our syllabus, our agenda for our discussion. We are necessarily, once again, looking to the Supreme Court, that palace that sits across the parking lot from the Capitol building in Washington, D.C., constructed in 1935, and even long before that, of course. The place that announces the principal issues, the principal resolutions of major issues in our nation. No exception to that in recent weeks, months, years, and even decades, as the Supreme Court continues to pick up on what one of our first Chief Justices said, that is that it is most markedly the province, and it is the responsibility of the courts to tell us what the law is. That's not explicitly in the Constitution, but it sure is in the Federalist Papers, and it certainly does animate an awful lot of what our founding fathers intended when it comes to understanding the three branches of government and the checks and balances that exist between the judiciary on the one hand, the Capitol, the representatives in the House of Representatives, our senators in the Congress, and of course in the executive branch at the far end of Pennsylvania Avenue and beyond, there in the White House, executive agencies and beyond. Those, of course, as you well know, those are the three branches of our government, federal system, also state system, also reflections of that tripartite notion of government in our local and our county governments as well. Why do I raise that again at the top of our 2-hour program this weekend? Because, boy, does it animate an awful lot of what happened just this past week when it comes to decisions being made by the executive branch, being reviewed by judges in the judicial branch, and yes, as always, the legislative branch, intended unmistakably to be the big muscular entity inside our government, not completely silent, but certainly in terms of legislation on these major issues, not hearing a lot from our legislators when it comes to these major disputes and non-disputes between the executive branch and members of the judiciary. We're going to spend a lot of time talking about the United States Supreme Court because, once again, many decisions this past week in recent days that animate our understanding of the ways in which our government works. And those necessarily focus a lot upon international matters. You know what they are. You've been attentive to the news stories of the past several weeks and days and even hours. Many of them, if not all of them, focus on immigration and immigration issues writ large, meaning lots and lots of invocations of immigration issues for many human beings here in the United States, some of them plainly no longer here in our nation, and then some very particular individuals. You know what their names are as well. Abrego Garcia, that is a name we will talk about a lot during our broadcast, and also Mahmoud Khalil, who has gotten a hearing not in front of the Supreme Court this past week, but in front of an immigration judge. We'll talk about where those immigration judges are located inside our Department of Justice. And yes, that is indeed where they are situated. We'll talk about the impact of a decision made just recently by an immigration judge. Not the final word when it comes to that Columbia student. Not the final word when it comes to Mr. Abrego Garcia, who is this 15-year resident of the United States of America. His family, citizens of the United States of America. Mr. Abrego Garcia, as you know well, still presumably in that high-security, brutal prison in El Salvador to which we transported him, along with somewhere around 200 and 250 others on March 15th. They remain there. The United States Supreme Court just this past week issuing a number of decisions that in many ways support but also clip the tails a bit of the administration when it comes to these immigration issues. We'll talk about all of that. Venezuelan migrants, immigrants, once again looming large. We'll talk about the consequences of one of those decisions. Some district court judges already taking up the invitation of the Supreme Court to grant due process, due and owing to every person who's geographically here in the United States, whether you're a citizen or not. A couple of courts in Texas and New York, we'll talk about them. What are they doing in the wake of the Supreme Court's decision that says that indeed the Trump administration can use this thing called the Alien Enemies Act to deport people in a time of war, in a time of not just controversy, but a time when alien enemies are presumably posing a threat to our nation. We'll talk about what the Supreme Court said, what those district courts are doing, and then we necessarily have to talk once again about the Supreme Court, the oral arguments. You recall from our broadcasts of recent weeks, we've spent some time chatting about the recent, very important oral arguments before the Supreme Court, a number of different areas. We have yet to tell you more about what happened in a Clean Air Act case of recent date, and also a case involving something called the non-delegation doctrine, having to do with the internet access and the federal laws that maybe enhance or prohibit the provision of internet services throughout our nation. We'll talk about what all of that means in connection with recent oral arguments of the Supreme Court. Finally, on this very ambitious, but again, achievable agenda, this ambitious syllabus, we necessarily need to talk about something else that our president did just this past week. Once again, not only crossing a line that has not been crossed before, with some perhaps notable exceptions in the past that resulted in bad things for our nation. This president, once again, crossing that line and basically telling the United States Department of Justice that it needs to open up files. It needs to open up a file with respect to a former employee on the payroll of the White House in the first term, another one who also apparently ran afoul of the current president's views about the world, sending information to another agency indicating that that person should likewise be looked at to determine whether he has violated the federal criminal laws, whether he is treasonous in his past behavior. That kind of behavior, which again animates this president plainly, this is the retribution about which he spoke during the course of his campaign. It was brought to life loudly, clearly, unmistakably this past week when Donald Trump not only identified these two individuals for the opening of files inside our Department of Justice, inside other agencies of our government, and instructing members of his staff, of his administration, to look at these people That is a line. That is a line crossing that arm's length relationship that I've spoken about so much on this and other broadcasts that needs necessarily to exist to ensure that the president and the appropriate political and partisan views that he, perhaps one day she has, do not infiltrate, do not affect the prosecution decisions of the prosecutors, namely assistant United States attorneys, deputy administrators inside the Department of Justice, the litigating trial attorneys inside Main Justice, whose role, whose oath commands them to do what? To engage in a review of the facts and determine whether or not, under the existing law, reasonable, rational interpretations of that law established by the Congress, whether there is reason to believe that there is probable cause that a crime has existed. That inquiry, that's what's animated the Department of Justice for well over 200 years. That is what the President of the United States of America just this past week crossed, and setting up the possibility that others down the road will likewise be referred by him to agencies, including the Department of Justice, others in the administration, for retributive action, and action that is plainly promoting the president's own view that these people, his foes, his enemies, as he has sometimes described them, should in fact be on the receiving end of at least investigations and perhaps even criminal prosecutions. All of that happening this past week, and we are going to get to that, all of that, here on Amicus, a Law Review, here in the broadcast stations of Civic Media. Once again, that number is 855-752-4842. Yes, indeed, it is a lot. It's a lot to consume, a lot happening in the area that we need necessarily to understand, to appreciate, and again, to digest and assess, as all of us should, when it comes to the future of our nation and the understanding about not just how civics work, but also how our government works and how it should work. And once again, the all-important notion of separation of powers, balance of powers, the notion that each one of them checks and balances the others. What are the consequences when that doesn't happen? What are the consequences to the republic, as Benjamin Franklin said, if you can keep it? Let's begin in the last moments of this first segment to identify exactly what the Supreme Court did just on Monday, indicating that the administration can, in fact, continue to deport Venezuelan immigrants using that wartime peace power, that war power that, again, has been much the subject of review and analysis by the federal district courts in recent days. When we come back, we'll talk about that major decision under the Alien Enemies Act issued by the Supreme Court and the footnote to it that's all important as Amicus, a Law Review, continues.
You're listening to Civic Media. Stay up to date on the latest news and information for your local community and Wisconsin by signing up for our free email newsletter. Visit civicmedia.us/email to get started.
My name is Jim Santel, and this is Amicus, a Law Review, here on the broadcast stations of Civic Media. Honored and delighted that you once again have chosen to spend some time, your time this weekend, in conversation with me about these major issues, beginning and ending today with the United States Supreme Court and major decisions, although of an emergency and temporary nature. We'll get back to that, this so-called shadow docket, these emergency applications that continue to increase in wild numbers under this administration, under previous administrations too. We'll begin by talking about what the Supreme Court did on Monday of this past week. Monday night, the ruling that the Trump administration, Donald Trump, can in fact continue to deport Venezuelan immigrants using the Alien Enemies Act. That is this legislation passed a very long time ago that says that if indeed we're in a time of war and the nation is threatened by alien enemies, the president does have the capacity to identify and remove people who are enemies of our nation in wartime, including times of invasion. And the significance, of course, is this, that the Supreme Court has effectively endorsed implicitly, but effectively endorsed this notion that we have been invaded and that we are indeed in a time of war having to do with the Venezuelan migrants, and particularly these members of a gang there in Venezuela and throughout the face of the planet. Let's talk more about what this decision is all about coming out of the Supreme Court just this past Monday. The justices, again, on this emergency application coming in from the Office of the Solicitor General, from the U.S. Department of Justice, asking that the court permit the president to continue to enforce the Alien Enemies Act with respect to these Venezuelan migrants, again, allegedly members of this high-level violent gang out there. You recall well that all of this started almost a month or so ago on March 15th when the executive branch, the president, and his staff, his assigned employees in the executive branch, placed on airplanes and sent to El Salvador about 250 so-called migrants, so-called Venezuelan gang members. We don't know for sure because we haven't had the due process the Supreme Court has now directed they have, sent them off to Venezuela and that prison. And that has sparked, of course, a huge amount of controversy, not only by virtue of that conduct, but also what's been going on in court. We have spoken a lot about what this district court judge, his name is James Boasberg, has done, his attempts to try to say, no, you do not have the authority to do any of that, Mr. President, until you are affording all of these people due process to prove who they are, what they have done, the basis for deporting them. And, of course, one of the not insignificant sidelights aspects of that review by James Boasberg is whether or not the administration simply said no, simply thwarted what the judge had said and sent the planes off to El Salvador into that prison, absent following what the judge had explicitly ordered. To this day, frankly, weeks later, the judge still doesn't have a decision because he doesn't have the information provided by the Department of Justice about exactly what happened on March 15th, which is the subject of plainly his continuing review of all of this. In the meantime, the administration, through the Department of Justice, appeals all of this, seeking before the United States Supreme Court one of these emergency applications to say, tell that judge he's got no business playing in this field. He cannot invoke, cannot interpret, cannot apply the Alien Enemies Act in a way that prohibits the administration from doing what it has done, and that is deporting these Venezuelan migrants, presumably including not just those on March 15th, but others. And we know that there are others here in this nation also subject to this broad sweeping directive of our president. What happened is that the United States Supreme Court, upon this emergency application, again, seeking to have the district court judge Boasberg told you can't be doing what you're doing, basically permitted the administration to go ahead under the Alien Enemies Act, making expressly that finding that indeed the president does have the capacity to do what he is doing. The question, however, was where should those cases be filed? And the judges said the case in particular that they were focusing on others should have been filed in Texas, where the Venezuelans were being held, rather than a court in Washington, D.C. They basically said you've got to go to the specific district court in which you are located, in which you are being held, in which you are being detained by the government, setting up the notion for there being huge numbers of what we're calling habeas corpus petitions. Habeas corpus, as you know, this notion that you can run into court and ask a judge to make a finding that indeed you or the person you're representing is being improperly held by the government, and release the body is plainly what the notion is until justice can be done. To effect justice, that's what habeas corpus is all about. The Supreme Court early this past week said that indeed the Alien Enemies Act can in fact be invoked by the president, but you have to afford all of the people who are the targets, the subjects of removal under that act, you've got to afford them due process. You've got to give them an opportunity to be be told, number one, what it is that they have done, what are the allegations against them, and they've got to be given the opportunity, the option to defend against them, to present to the courts some sense of what they have done. All that's got to happen, according to the Supreme Court, within a reasonable time for them to challenge their removal before they're deported. That finding could impose some significant new restrictions, again, upon how the Trump administration goes forward from this point. Again, contemplating that there be individual lawsuits, individual applications in district courts, many of them plainly in Texas, but not exclusively, wherever these individuals are located, wherever they're detained, requiring that they, before they be deported, before the administration put them on planes, like the administration did for those 250 others now in El Salvador, before you do that in the future, you have to afford them due process. That's what the Supreme Court said. It is plainly a mixed bag. There are plainly those individuals on both sides of this fight who are declaring victory, declaring defeat, not only because of the mixed nature of the ruling. The justices, in many ways, are splitting over where and how that should happen. The court order, which again is unsigned, it's very brief, said the detainees are confined in Texas in this particular case, so venue is improper in the District of Columbia, once again suggesting that with respect to future applications, future challenges to deportation, what has to happen is that the petitioners have got to go in the individual federal district courts around the country and seek relief from district court judges. We know that there are many of those district courts, and we know that indeed 2 federal judges, even in the wake of what happened early this past week, 2 judges in New York and Texas, in fact, stopped and curbed deportations of Venezuelans to El Salvador using that very, very mechanism and invoking the due process that the Supreme Court says you've got to have. Twin rulings in New York and Texas in direct response to what the Supreme Court decision was on Monday. Again, all of that happening while the issue of immigration and migration and immigrant status looms large under the Alien Enemies Act. Again, the decision of the Supreme Court that the migrants subject to deportation under the act have to be given what? They've got to be given notice before being removed and given an opportunity to defend against that. On Tuesday, 2 Venezuelans being held in detention in the town of Goshen in Orange County, New York, asked Judge Alvin Hellerstein to shield them from being deported. As we come back, I'll tell you what Judge Hellerstein did. I'll also tell you what another judge in Brownsville, Texas did. His name is Fernando Rodriguez, likewise implementing what the Supreme Court has done just this past week. We'll talk about all of that and more here. This is Amicus, a law review. My name is Jim Santel, your host this hour and next hour as well. Talking necessarily once again about the United States Supreme Court. A series of major rulings of just recent days, including this major ruling in which the Supreme Court once again cleared the way for the administration to deport Venezuelans. However, to do so under the understanding that they be afforded due process within a reasonable time, given opportunity to challenge their removals before they are deported. And of course, that is a due process right that was expressly not afforded those 250 deportees who were the subject of deportation removal way back in mid-March. Supreme Court this past week saying you can go ahead and do that as long as you provide them with due process in doing so. Interestingly, Justice Sonia Sotomayor, writing in dissent, she says the majority's legal conclusion was suspect. That's her word. She asked if the court had intervened to grant the administration this extraordinary relief, this emergency relief, without mentioning what she called the grave harm that the immigrants would face if they were erroneously removed to El Salvador. The court, she said, should not reward the government's efforts to erode the rule of law. Interestingly, she is joined in that dissent, her disagreement with the majority, by the 2 others, so-called liberal justices on her side of the aisle. They are Elena Kagan, as we know, and Ketanji Brown Jackson. And perhaps no less interesting, Also joined, at least in part, in that dissent by, yes, that's right, Amy Coney Barrett, once again voicing her partial opposition to what the majority has said. Along the way, we've got these two district court judges in New York and Texas who've said, all right, Supreme Court, if you have permitted the review of these cases to go ahead, we're going to do just that. We've got cases pending in the district courts there, one of them in front of Judge Alvin Hellerstein. And he's got in particular the petitions of two Venezuelans who were held in detention in the town of Goshen in Orange County in New York. Judge Hellerstein, at a hearing on Wednesday in his court, issued a narrow decision in their case. He said that any Venezuelan migrants in his judicial district, that's the Southern District of New York, subject to deportation under the statute, have to be given the opportunity to have a hearing before they are removed from the country, making clear that if you've got potential deportees, people are going to be subject to removal in that district, you better have afforded them due process. Judge Hellerstein says, it seems to me that people need to be protected. Yes, indeed, Judge Hellerstein. And that is exactly what the Supreme Court has said. A broader decision, a second decision, again in the wake of what the Supreme Court did early in the week, handed down this time in Brownsville, Texas, by Judge Fernando Rodriguez Jr. He said the administration cannot use the Alien Enemies Act to remove any Venezuelans being held in the El Valle Detention Center and Raymondville near the southern border until at least April 23rd. And again, all of these Venezuelans bringing their claims in New York and Texas had been protected from deportation under the now superseded order entered by the Supreme Court. Supreme Court's ruling on Monday, once again indicating that all these cases need to be filed in the districts in which the deportees are located, their geographic location, and have to be afforded due process. We've got two judges who have already said, if you're going to go ahead under the Alien Enemies Act, Mr. President, and Department of Justice, you've got to ensure that all of these people are given their due process rights in America before you do that. The significance of all of this, of course, is really two things. One is it appears that the Supreme Court, in concert with the president himself, has declared war under the Alien Enemies Act. That's the tripping mechanism, a finding that we are at war, that we are being invaded. The Department of Justice apparently supporting that view inside the executive branch as well. The judiciary basically saying, yes, indeed, the president can, in fact, invoke the Alien Enemies Act. It itself is predicated upon a finding that we are invaded, that we're at war, and therefore the president's powers can be executed. Again, the other portion of it, equally important, equally significant, is it can't do this without due process. What of those 250 individuals who, yes, indeed, implicitly, explicitly, now we know, based upon the Supreme Court's order, should have been given due process before they were packed up and sent in those planes to El Salvador on March 15th. That is the reason why Judge James Boasberg, the district court judge in the District of Columbia, has been so animated for these past several weeks, not even getting yet to the decision about whether or not the Alien Enemies Act is properly invoked, but finding that certainly there's been no process and asking the government repeatedly for this information about whether or not the Department of Justice, the Department of Homeland Security purposely decided not to abide by his direct order on that day, not to send those planes on. To this day, the United States Supreme Court and the executive branch affirming, again, now we know under the law that apparently the president can, in fact, do this, but not giving an answer. The Department of Justice is not giving an answer to this all-important question about whether or not those planes were sent off in violation of Judge Boasberg's order about a month or so ago. That still pens before him, and that is a matter that remains for resolution by the district courts. It is a fascinating time for understanding how our courts work and the interplay, again, between the United States Supreme Court as it continues to address many of these issues related to emergency applications in our nation. The other one we necessarily need to address as we continue to understand what's going on in our nation is this particular case involving the Maryland man, the man who's been in our nation for 15 years legally, lawfully, We know that his name is Kilmar Armando Abrego Garcia. And we know that the government, the Department of Justice, in hearings in front of the appeals court, the district court, has admitted that he was improperly included among those 250 deportees on March 15th. He is presumably, we don't know about his status, again, because the Department of Justice has not told the judge anything about that. The Department of Justice continuing to stonewall, to not tell the judge about his status. What do we know with all of this? Well, we know, first of all, the Supreme Court on Thursday, specifically instructed as to this particular migrant, instructing the government to take steps, important, we'll get back to that, to return this Salvadoran migrant. He's been in this country for 15 years. His wife, his children are citizens of this nation, that it had wrongly deported to that notorious prison in El Salvador. Once again, an unsigned order. The court stopped short of ordering the express return of the migrant in some very curious language, directing that instead the judge and the government do all that it can do to facilitate and effectuate the return of Mr. Abrego Garcia. How disappointing it is that our United States Supreme Court, at the hands of the Chief Justice and the other justices, do not simply say, bring him back, period. It's a very simple sentence. Instead, they say the order properly requires the government to facilitate Abrego Garcia's release from custody in El Salvador and to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador. And then it's followed by this very curious language. The intended scope of the term effectuate in the district court's order is, however, unclear and may exceed the district court's authority. Well, that language, of course, being seized upon by the administration, by the Department of Justice, to suggest that maybe the Supreme Court does not, in fact, mean to direct that Mr. Abrego Garcia be returned. And indeed, as this matter gets back in front of the judge, we've talked about her before, District Judge Paula Zinis, Z-I-N-I-S, she has a hearing just on Friday of this past week, is again one of these miraculous, unbelievable, stunning hearings in which representatives of the U.S. Department of Justice failed to provide her, as they did Judge Boasberg, with any information that's relevant to the questions that she is now asking. She has been told now by the Supreme Court, as of Thursday of this past week, that indeed Mr. Abrego Garcia should be returned to this country. She has the hearing on Friday of this last week. And the Trump administration continues what can only be described charitably as its stubborn fight. It's actually just in contempt, candidly, of the district court against securing the freedom of this Maryland man. It acknowledged it had improperly deported to that Salvadoran prison last month, despite this court order that expressly said he could remain in the United States. Combative stance? You bet it was. The administration once again defying this federal judge's order to provide a written roadmap, which is basically what the Supreme Court told her she can do. The roadmap to try to figure out the plans to free Kilmar Armando Abrego Garcia. Repeatedly stonewalling her in this effort on Friday to get the most basic information in this judicial hearing. During the hearing in that court in Maryland, the judge saying that the administration's evasions, and that's a charitable word for it, were extremely troubling. She demands that the Justice Department provide her now with daily updates on the White House's progress in getting Mr. Abrego back on U.S. soil. She says this. She said the court finds that the defendants have failed to comply with this court's order. That is an express statement that basically you are in contempt. The conflict, again, appears to be about this curious language from the Supreme Court having to do with facilitating the return and doing those things necessary. And the White House, again, seizing upon some of that curious and serpentine, circuitous language in this Supreme Court order to say that, well, in fact, maybe, just maybe, the Supreme Court is not requiring that he be returned, and in fact prompting the kind of non-responses by the government in front of the judge just this past week. When Judge Zinis asked what the Trump administration had done so far to facilitate the release of Abrego Garcia, again, the representative of the government, he is the Deputy Assistant Attorney General named Ensign, we've talked about him before, replied, he said, the defendants are not prepared to share that information.
And Judge Dennis responded, that means you've done nothing. Hugely frustrated, she says, we're not going to slow walk this. She says the demand for information about the government's plans was an issue that the Supreme Court has already put to bed. And she is now effectuating the Supreme Court order. She is angry. And she's ordered yet another hearing for this coming week. Along the way, a dispute, of course, between the government and between the judiciary, which is not yet resolved. Meanwhile, Mr. Abrego Garcia continues, presumably, to be in that prison, while once again we have got this fight between the judiciary and the executive branch, what can only be interpreted as a clear statement, although with curious language from the Supreme Court saying, get him back here. It would have been nice if the Supreme Court had not engaged in this sort of committee-generated order that maybe gives the White House some wiggle room to say their language is unclear. It is not. It is not, but gives them a basis upon which to tell the judge we're not providing you with that information. Why is this so hard? In fact, what should happen in a nation that understands the importance of all human beings, understands the importance of a Supreme Court order, what should happen here is just this: that the United States Department of Justice should appear in front of Judge Dennis and should have said, we've gotten the Supreme Court's order. We are working right now to get him back. We can provide to you, Judge, in camera without going expressly public about the specific things we're doing. We can tell you privately what we're doing to assure you that we're doing everything we possibly can to get him back. That's not what your Department of Justice is doing right now. In fact, another hearing now scheduled for this coming week in which this dispute will continue. It goes on and on, does it not? It is not just frustrating. It is frankly, once again, as we saw last week with respect to Judge Dennis, especially with Judge Boasberg, these attempts by the Department of Justice not to abide by what a federal district court judge says, now arguably in contempt here as we go forward. All of this prompting an awful lot of concern around the nation, among legal authorities, among other jurists, among people like you who are concerned about the rule of law in America. And that includes our callers. We appreciate very much our callers calling in on a regular basis to talk just about that. We know that many of you are concerned about these same issues, and we're going to talk more about what all of this means as we continue with our broadcast. And we're going to focus not only upon Mr. Abrego Garcia, but others. I'm going to take some calls and some of your observations here as Amicus, a law review, continues right after this.
You're listening to Civic Media. Find the latest news, information, and archives of all your favorite shows on the Civic Media website, civicmedia.us.
This is Amicus, a law review, spending the huge amount of our first hour talking about immigration and the interplay between the actions of our executive branch with respect to these Venezuelan migrants or immigrants, variously in El Salvador, not in El Salvador, now required to file habeas corpus petitions in the districts in which they are venued, talking about what is happening now in the federal courts, including that federal court in Maryland in which the judge is searching for information from the Department of Justice about exactly what is happening, exactly is happening with respect to this Maryland man, now basically directed to be returned to this nation by the Supreme Court, admittedly using some curious language that could have been a whole lot more explicit. The judge saying, yes, this is indeed explicit. This is the Supreme Court saying, I'm now responsible. Upon remand, which is sending the case back to the lower court, I'm now responsible for getting this done. Bring this man back. The Trump administration is saying we're not prepared to give you that information. And not only tense exchanges, but really a meltdown between the two branches of government here. Clearly frustrated, the court saying that the government is running around the legal obligations now imposed by her, by the Supreme Court, And she also says that the government is now blinking at reality. Blinks at reality is what she says the Attorney General of the United States of America is doing in refusing to provide information, presumably refusing to do anything to get Mr. Abrego Garcia back in this nation, which should be hugely concerning for everyone. We've got a lot of people commenting and calling in. We'll get to them now. From Rocker, we've got a very nice note. Thanks so much, Rocker. Rocker says, I love your show and how you explain complex legal issues in layman's terms without any name calling or labeling. Always spot on. Appreciate that observation, Rocker. That's our purpose here. We're going to be clear when I have a perspective on how these things can and shouldn't do work out in our system. Sometimes do not. But we should always approach this in a way that doesn't involve name calling. We have rights, obviously, under our First Amendment to disagree, and you've got a right to disagree with me as well. Some of these things, however, require some advocacy and some understanding beyond just a clear statement of what is going on. And Rocker, I appreciate your understanding what Amicus is all about, what this broadcast means. Thank you so much for the very nice comment here on our weekend broadcast. We've got other callers on the line. Let's go first to Ross. Ross, you've been waiting on the line for a while. Appreciate your participation in our discussion this weekend.
Good morning, Jim and team. And yes, and I agree with Rocker. Thanks for kind of shepherding us through these legal issues, because it seems as if our legislative process is kind of bogged down. There's no sort of bipartisan, so it's one team versus the other, and it seems a lot of the big issues are landing in our judiciary. So the question that it kind of a little bit of a step back, but I think it's related to what you're saying, is there's this is it the plaintiffs where the team has to make sure that they that they bring their court case in the appropriate location. And then the other thing that I hear in the news, and I think it's related to this, is this: there'll be all this work. They'll come to the court, and then the judge will say, "You don't have standing." To me, it seems kind of like, wouldn't this seems to me like really basic stuff. Like if I have a legal team and I'm gonna take on somebody's case and bring it before somebody, I want to make sure that I have standing,
right?
Versus like, I feel like you're wasting all this time. Anyway, thank you. Yeah.
Ross, thanks so much for the very good comments. We appreciate also your endorsement of our mission here. You've got it just right. That's exactly what the Supreme Court has said. Again, in this sort of mixed ruling back on Monday, they said, yes, indeed, under the Alien Enemies Act, which apparently we can now invoke. Apparently we're at war here in the nation. The president can do this, but you've got to do it by affording due process, and you've got to do it. And this is where some of the justices part company with the majority, the 9 justices agreeing that they all are those detained in the United States must receive advance notice. The question, again, is where that has to happen. A lot of these things happening in the District of Columbia, because that, of course, is the seat of our government. The court saying that these particular detainees who are the subject of this particular lawsuit confined in Texas, and so you've got to go into a district court there, not in the District of Columbia. And that poses plainly certain hurdles, Ross, that I think you're expressly, if not implicitly, stating here as well. And that is, you've got to have individuals either on their own, perhaps better represented by good civil rights lawyers. And we've got a great number of them here in the nation, including in Texas. You've got to go in and represent these clients all individually. Can't do this as a class action lawsuit. Got to go in and say, this particular client of mine, this is who he is. This is what he has done. He is not a member of this gang. He may have some tattoos. He may have some other indicia, but you have been misled into believing that he is a participant, that he is an enemy of this nation and therefore should be deported. That's what the due process is all about. And those have got to be done individually now, which is apart what our due process contemplates. But you got to do them in the district in which you are located, in which you are detained. That poses some problems plainly in terms of getting representation for all of those people, getting all of that in place. Now, with respect to the other important issue that you raised, Ross, standing. No doubt that if I am the subject of a deportation order, I'm going to be deported, I've got standing to come in. Why? Because I can articulate to the judge the specific harm that's going to happen to me if indeed this goes ahead. Unless you stop this from happening, I'm going to be damaged by that. That's standing. What you are hearing, Ross, in many other cases, including others that we'll get to this broadcast and next, is other groups coming in and saying the Department of Justice is wrong when it says that it can do these things on behalf of the executive branch. President is wrong. And the courts saying that you yourself, as an entity, as a group, we know some of them, they're nonprofit organizations coming in, basically speaking on behalf of individuals. You don't have standing because you yourself are not subject to the damages, to the harm that standing requires. In these cases involving immigration, it's difficult to imagine that a court would find that there is no standing. Why? Because the ultimate damage would be here. Removal of this very person who could be harmed perhaps unlawfully, illegally, if indeed the deportation goes ahead. But standing looms large in all of this. And yes, indeed, the Supreme Court is finding that as a basis in other cases, challenging these other executive orders to say that there is not standing, and therefore we're sending them back down and refusing to enjoin some of the actions of this president. Great call, great inquiry, Ross. Appreciate that very much. Let's go on to others who are also calling in. Dan, you've been on the line for a while. Dan, I appreciate your contribution to our discussion today.
Hello?
Yes, Dan, we've got just a few seconds. Yeah, Dan, go right ahead. We've got just a few seconds here, and go ahead.
I didn't even know you were talking to me now. Sorry.
All right. Dan, here's what I'm going to do. Hang on. We're going to take you at the top of the hour here as our broadcast continues, and we'll get your comment, your question, and we'll look forward to talking with you. Stay with us. All of you stay with us as Amicus, a law review continues.
Welcome to Amicus, a law review with Jim Santel, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santel.
This is Amicus, a law review here on the broadcast stations of Civic Media, spending virtually all of our broadcasts this weekend on these important issues related to process inside our Supreme Court, lower courts, appeals courts, how this all works. Appreciate very much the comments, the questions, the inquiries coming in from all of our listeners, specifically focusing upon these Venezuelan migrants, some of them who are still in this high-security, brutal prison in El Salvador without information being provided by a district court judge named Boasberg in the District of Columbia. Another one, it was the subject of a specific petition previously pending before the Supreme Court. His name, of course, Kilmar Armando Abrego Garcia. He's been a 15-year resident of this nation, properly here, improperly, unlawfully deported by the government a month or so ago. His wife and children, citizens of this nation, are asking for his return. The Supreme Court saying, in effect, yes, accomplish that, but giving a little bit of leeway to the diplomatic and international authorities of our president, which the president now seizes upon and says, well, maybe I don't have to follow what the Supreme Court is saying. The district court judge, her name Zinnis, Paula Zinnis in Maryland, saying, no, the Supreme Court has directed you, government, to return Mr. Abrego Garcia back to the United States. Do it. You are in basically contempt. You failed to follow my court order, and you need to do that. I'm ordering you to give me daily updates on what you're doing to get him back to this nation. More of that coming as this fight between the judiciary, even in the wake of the Supreme Court's ruling, and the Department of Justice, Department of Homeland Security, and the White House itself continues without clear resolution, raising once again, as we've talked about before, the prospect that unless this is resolved in some way, unless somebody says, yes, indeed, and that somebody should be the President of the United States of America, I will follow what we've done for 238 years, which is follow the directives of the Supreme Court, of a district court, and I will get Mr. Abrego Garcia back. I will afford all the other Venezuelan migrants who I'm seeking to deport under the Alien Enemies Act. I'll give them the due process they are deserving under habeas corpus petitions in those districts. I will do all of that because judges have directed that we do that. That's what our president and that's what our attorney general should be saying. They are not, at least not to this point. We've got callers in right before the top of the hour break. Dan was on the phone with us. Dan, appreciate your being a part of our discussion. Appreciate your staying with me over the top of the hour break. Let's get back to you.
Yeah, sorry about before. There's no screener. Confused me. I just want to know what kind of precedents, without, you can say they're in contempt, but without actually doing something, punishing them somehow, finding them, jailing, whatever. What in the future, let's say I have a savvy lawyer and he's handling my criminal case and he just says, yeah, I'd like to cite the Trump administration versus the federal government, and we're not going to listen to you.
Right.
Is that possible?
Right. What happens, right? Exactly. Whether it's your attorney, somebody else's attorney, it is a great, once again, it's a civics question. It is a constitutional procedure question, and there are answers to that. Dan, I appreciate your identifying this. So here's what happens. We have seen in front of Judge Boasberg just last week that he was very close. He is basically finding that the government has not complied with his orders. He had indicated that he wants to know who the contemnors are. That's the fancy word, the lawyer word for who are the people who are not following my orders, to tell me when those planes left, what happened, where they are right now, who are the people, who are the names? Is it the Attorney General? Is it Deputy Attorney General? Is it you, the attorneys who are appearing in front of me? Is it somebody in Homeland Security? Who is not following my orders in not only giving me this information, but also affirming for me what the status of these 250 Venezuelan migrants exactly is? That hasn't happened. Now, the contempt movement, which is what Judge Boasberg was headed to, was effectively suspended while the Supreme Court took all this up. Now we're back again. It happens to be now in a different court. It happens to be in Maryland, having to do with this case involving Abrego Garcia. And the judge, once again, like Judge Boasberg last week, is once again hugely frustrated. She is angry with a small a in a judicial way with the government for not providing this information. She also says you are, she doesn't use the contempt word, but she says you're in violation, again raising the prospect of a constitutional violation here, a constitutional crisis here, and she's directing the government once again to give that information. What is the solution? Where does this come to some resolution if, in fact, the government, your Department of Justice, your White House continues to say, no, we're not providing the information. We're not going to answer your questions, judges, even though we are now compelled by the Supreme Court, at least one of these cases, to bring this particular resident back to the United States? And the answers are, under contempt authorities in a district court, the judges can do a number of things. They can impose sanctions, and that goes to kind of, Dan, your question, your thought about what can happen to lawyers and parties. Impose sanctions. You can or cannot do certain things in the very litigation. You can't raise issues. You can't discuss things. You cannot engage in certain kinds of discovery. Those are possible options. Difficult to imagine exactly what those would look like in these cases and involve basic civil rights. But you can also impose fines. You can fine the parties who are in contempt $100, $1,000, $10,000, whatever you think the fine should be, basically to say I'm penalizing you for not doing what he said. This is quite literally just penalizing the group, the entity, the person who's not following your rules, your regulations, your directives. And yes, indeed, here's the big one, which we have talked about before. The federal district courts, as do state courts, have the capacity to incarcerate. You've got to make findings. You've got to have hearings on this. It's got to be a contempt in your presence. But if there's criminal contempt and you've established a record, which plainly these attorneys appearing in front of Judge Boasberg and Judge Zinnes have done, you have failed to do what I have said, and my earlier recommendations, not just recommendations, my directives to you have gone unfulfilled. I am going to jail you. And as Judge Boasberg said last week, tell me if you'd like to think about purging yourself of that contempt by giving me the information, by returning these immigrants to our nation. You can purge yourself, but that's a judge who's talking about putting somebody in jail, finding you're in contempt, finding you are, in fact, getting us to the point of a constitutional crisis. That's one of the remedies. The question, Dan, of course, would be, who is that person?
You can't just incarcerate a non-entity that doesn't have some corporeal existence. And is it the attorney general? Is it the attorneys who are appearing in front of you? The judge wants to know, in the case of Boasberg, who is it who actually told those planes to move on, and when did they do that? Did they do that after I entered this order? And if so, I either want their names or I want them to appear here to explain what it is they did and did not do. That's a judge exercising her appropriate authority under these circumstances. Incarceration, as stunning as that may be, is an option here. And it is one that, frankly, is on the minds of these judges because they are being stonewalled by your Department of Justice, which is, from my perspective, having served 30 years in the Department of Justice, I have not witnessed that before. And again, when judges told me and my colleagues to do something, you can appeal the decision, as this administration has done. But once you've got an order from that appellate tribunal, you're obliged to follow it. You're obliged to follow it. And that's the reason why we are in crisis here in America today. Dan, appreciate the comment, the observation so very much. I also have Dale calling in from Wausau. Dale, appreciate your involvement in our discussion this weekend.
Yeah, thank you so much. I appreciate that, Jim. This denial of due process is one of the biggest items, in my opinion, that has come forward. And this is just one more step towards authoritarianism in the Trump administration. And I think the Supreme Court has to be a little bit more muscular,
yes,
as Robert's words, last summer when he gave Trump this immunity. And this could affect, denial of due process could affect anyone in our country. Let's take Dr. Fauci. Okay, so Dr. Fauci, not given due process, he could be scooped up and on a plane to El Salvador. And like I had said last Saturday when I talked to you, Jim, that El Salvador is now Trump's Siberia. Putin puts his political adversaries in prisons, El Salvador like prisons in Siberia. And even some of these cases, rulings where protesters can't wear masks, they want to be able to identify who that protester is and deny them any due process. And guess where they're heading? They're heading to El Salvador then also.
Dale, the point you make is so compelling. Again, it's
really
exactly.
a troubling thing.
Right? It is important, hugely important, of course, for anyone who gets the benefits, as does anyone who is physically here, the benefits of our Constitution. But you raise a very good point, which is the implications of this far beyond just the Alien Enemies Act. We're going to talk in a little while about some of these other things that the president has done to identify people who have run afoul of him. And the question, as you say, with respect to Dr. Fauci, has not yet been identified. What is the retributive action by this Department of Justice, by this White House, and the implications if indeed people are not afforded the opportunity to defend themselves, to say, you know what, my government has it wrong, I'm not who you think you are? That's a basic fundamental premise. When I did criminal prosecution, that's what we fought hard to ensure, that every single defendant who comes before the judge, before a jury, has that full and fair opportunity to explain that, frankly, I'm wrong, the government is wrong, the U.S. Attorney's Office is wrong about the prosecution, and have an arbiter, a jury, a judge make that decision instead of having the executive unilaterally do that and pack those people off and send them to an incarcerative setting without that due process. Dale, the importance of due process cannot be overstated. We've also got Hendricks Valor calling in, and we've got many other callers coming in. We're going to talk with you, Hendricks, in just a few moments here as Amicus, a law review continues. Also going to talk more about standing in our next segment as well. This is Amicus, a law review. My name's Jim Santel, taking terrific, as always, terrific callers, great questions, great observations, and that includes some of our recent callers, Dale and Dan and Ross, calling in already. Rocker also being a part of our discussion in our weekend broadcast. Ali now on the line, calling in as well. Ali, your question or your inquiry?
Well, I guess I'm questioning Mr. Trump, how he could possibly be so ignorant that he thinks it's okay for him to get away with this when he's a convicted felon and was afforded every chance at having the proper prosecution and wherewithal of the
court processes, right? Exactly.
Yeah.
Right. Ali, you're probably thinking of that again, among others. We know that there were an awful lot of federal cases there that were dismissed, but the one that I suspect you're remembering here is Donald Trump appearing in that Manhattan criminal court and being afforded again to provide witnesses and to defend against these allegations brought by the district attorney there involving the hush money case. Afforded all those opportunities. That's what due process is all about, Ali. I think that's what you're contemplating and asking the question, scratching our head. They've got a president who is given those opportunities. He remains a convicted felon to this day. The appeals court is still looking at that case. But afforded those opportunities, even in all the other cases, even the other civil cases that are pending. It's always process. It's always about an arbiter making a determination about who is right and who is wrong, or who is mistaken, who's spot on, so to speak. And I appreciate your observation here. Other thoughts you have about any of these due process issues?
Yes, there is. I'm concerned about the wishy-washy way the United States Supreme Court voiced their opinion yesterday. Even though they said that man must come back, they refused to stand up to the monster they've created. And what happened the next time when, like he said, he wants to deport United States citizens who have, according to him, broken the law. Well, who is he to decide what laws are broken when he will not give them the right of due process?
Absolutely. And that's exactly what the Supreme Court has said. And Ali, you're also, of course, bemoaning, as do I, as I suspect many of our listeners and others in America do, the notion that the United States Supreme Court simply didn't say clearly, unequivocally, bring him back. 3 words. That's all you need to do. And in fact, now you've got Donald Trump saying things like, a spokesman for the White House saying the Supreme Court correctly recognized it's the exclusive prerogative of the president to conduct foreign affairs. Went on to say, by directly noting the deference owed to the executive branch, which is unfortunately what the Supreme Court said. And it's true. There is appropriate deference to the executive branch on many things, not all, involving international matters. So the ruling once again illustrates the activist judges do not have the jurisdiction to seize control of the president's authority to conduct foreign policy. Ali, that's the language you're bemoaning inside an order that's very brief, didn't have to say all those kinds of things. In this instance, simply afford this human being who has rights under the Constitution the capacity that we've afforded to everybody else, which is to be returned to this nation, a mistake having been made of the highest order, get him back here. And now we've got a White House that's using this circuitous language to justify its decision, apparently to tell Judge Zinnes that she does not have the capacity to tell them what to do. And that's the difficulty of a less than clear order. Ali, appreciate all your observations as always in our broadcast. Appreciate also Matt from Middleton writing in that says, when those at the top ignore the law for everyone to see, why should the rest of us why should the rest of us abide by the law? How does that not lead to more black markets when these tariffs and other side effects happen? You know, Matt, once again, you're raising the issue of precedent, right? When, as Ali and others have said on our broadcast, when you fail to do it in this one case, You have opened up the door to failing to afford basic processes to others, failing to follow the rule of law, failing to abide what our Constitution says you've got to do. What are the implications of that in other instances? That is a huge concern and a legitimate concern, Matt, not just for these particular migrants, but as all of our callers have implicitly said today, for other circumstances where they're also seeking the redress of grievances. That's in our Constitution as well. It's in the First Amendment as well, right? The ability to petition your government for redress of grievances. That's what it's all about. Matt, appreciate that comment. Ali, appreciate your comment as well. And Mark, you're also on the line in our broadcast this weekend, waiting a while. Appreciate your contributions to our discussion.
Yeah, I think how dangerous it is for the Supreme Court to allow this to be called and for allow Trump to call this invasion. We're now at war. This is an invasion. An act of war. That because under Section 3, Article 3 of the Constitution talks about treason, giving aid and comfort to the enemy. Well, now, is advocating for Venezuelan immigrants? Is that advocating for is that giving aid and comfort to the enemy? Any criticism of our foreign policy under Marco Rubio? That's why we're deporting that 30-year-old student. That is that Kumar, I think that
right.
Because he just complicating our foreign policy, criticizing our foreign policy. Well, then that could be used for any citizen who's advocating against whatever foreign policy we have in this country. And for us to ship people to El Salvador, probably to impose upon them cruel and unusual punishment, which is a violation of whether that the Eighth Amendment to the Constitution. I mean, it is just the chasm
right.
can open up here
exactly.
With this stuff.
Opening up those doors once again, right, Mark? And the number of important, meaningful phrases that are not just phrases in the Constitution. They have meaning in the courts and in our land generally. Cruel and unusual punishment, due process, equal protection, all those things that are implicit and, yes, indeed, explicit in our Constitution need to be observed by all branches of government. We can disagree with what branches of government may do. That's also guaranteed to us under our Constitution. We can even be critical, as I am this morning, of a Supreme Court that did not provide the explicit direction and open up this door for some possible arguments to Judge Zinnes. We can do that without doing name-calling, without suggesting, as the President has, as the Speaker of the House of Representatives has, that the judges themselves have no power. That's the concern, right? When you open up those doors to those kinds of behaviors, where do you end up? And the concern once again, is that that's when the republic begins to crumble. Appreciate all of those comments and those observations as well. Earlier on, Ross also talked about this concept of standing and said, gee, aren't there times when the Supreme Court kind of invokes that? And the answer is yes. Here's a situation, Ross, where they did this just this past week. Supreme Court on Tuesday blocking a ruling that we have talked about before. Remember this judge named William Alsup, who had previously ordered that 16,000 probationary workers not be terminated, an early order from this White House. Well, the Supreme Court on Thursday blocked that ruling from that federal judge. He's in California, that had ordered the Trump administration to rehire those thousands of federal workers. Again, this is emergency docket, a brief order. Nonprofit groups had sued, and the Supreme Court there saying you didn't have standing. You're not the ones who should bring the case. The case can still presumably be petitioned and challenged down the road, but not by these particular parties. That's an instance where Ross's implication and concern about standing in full view. When we come back, we'll talk about more immigrants and more issues related to due process in America here on Amicus, a law review. This is Amicus, a law review. My name's Jim Santel. We are talking necessarily about these major stories coming out of the Supreme Court and other courts this past week involving the ways in which our nation and our Department of Justice, the White House, the executive branch, is handling these immigration cases, focusing, of course, upon the Venezuelan migrants, but others as well, and many of our callers indicating the implications of these decisions for people who are not yet the subject, if they will be down the road, but not yet the subject of targeted prosecutions, identifications by our government, and the implications, the precedent these kinds of things are setting. Len from Madison also writes in, is not the U.S. government engaging in abduction, kidnapping in support of a camp disguised as a prison? And Len, you should know that one of the appeals courts actually had embraced exactly your language in saying that with respect to Mr. Abreu Garcia, that this was an official kidnapping by our nation. Used that word to describe what our government has done with him. All the more reason for a government, any good government, including ours, to say we have made a mistake and we need to remedy that problem. We need to turn back, not the history. We can't change the history. We need to turn back the process and ensure that this person is returned forthwith to the government. That's what Judge Zinnes is now insisting on, encouraged and supported by the Supreme Court as this goes forward. Len, appreciate your comment as well. We know, too, that there are other matters involving immigration. One of them involves Mahmoud Khalil. You may recall Mr. Khalil was one of the many leaders of those pro-Palestinian demonstrations on the campus of Columbia University last year, and that the Secretary of State, Marco Rubio, relied on a rarely cited law declaring that Mr. Khalil's presence in the United States harmed American foreign policy and the interest specifically of stopping anti-Semitism, rescinded his status here, and indeed, just late this past week, yet another hearing going on, this one before an immigration judge. We need to talk about that, who these immigration judges are and where they're located inside our government. This particular immigration judge in Louisiana finding on Friday that the Trump administration could indeed, yes indeed, could deport Mahmoud Khalil, granting the government what is undeniably an early victory, although not a confirmed ultimate victory, in its efforts to crack down on these pro-Palestinian demonstrations. Mr. Khalil plainly at the top of one of them. The ruling, however, far from the final word on whether Khalil, who's a Columbia University graduate student, he's a legal permanent resident of this nation, will be deported. And we did talk a little bit about that. His lawyers will continue to fight in Louisiana on that front. We'll get to that in just a moment. And also then, very significantly, in New Jersey, Federal District Court entertaining a much related but different case there, arguing that Mr. Khalil's been targeted for his constitutionally protected speech. The constitutional issues at the heart of the case will most likely get a bit more of a fuller hearing in court in New Jersey than they did on Friday in Louisiana. For the time being, however, the decision of the immigration judge there, his name is Jamie Comins, Jamie Comins, affirmed the extraordinary power that the Secretary of State, Marco Rubio, has in asserting this right to target and deport this non-citizen, his name is again Khalil, for his advocacy on the campus. So what is this all about? Well, let's talk, number one, about where this particular judge is. Immigration judges are employees of the executive branch. They're not employees of the judicial branch. You might think, gee, how does that happen? Well, the answer is inside the Department of Justice, there's an Office of Immigration Review. They're not judicial officers in the sense of the third branch of government, the third article of our Constitution. And they often approve the Homeland Security Department's deportation orders. They are inside the Department of Justice, and it would be candidly unusual for a judge serving the U.S. Attorney General. That's who the boss is. We've seen a lot of focus on these judges in the past when it comes to the amount of work that they've got to do. They are administrative judges. They make these determinations inside an agency. In this case, it is the Department of Justice, headed by the Attorney General. They grapple with all sorts of questions, but they're narrow questions. And typically, and this is the important point, they don't grapple with larger constitutional issues. And again, Judge Comins said, as she was delivering her order, she said,
I'm not addressing specifically these larger issues. She said she would also run the risk of being fired by the administration if she went down that road. She feels she's got no jurisdiction to do it. She might be right on that particular thing. She said this: the court is without jurisdiction to entertain challenges to the validity of this law under the Constitution. That's Judge Coleman said as she's delivering that ruling. She denied Khalil's lawyers' request that they also be permitted to cross-examine or even depose our Secretary of State, a petition that's long been pending there, so that he could elaborate on his claims. She said the court is neither inclined nor authorized. I don't have the power, she said, as an immigration judge inside the Department of Justice to compel that testimony. And again, it comes at the end of a fairly remarkable hearing, about 2 hours there in Louisiana at the LaSalle Immigration Court. Mr. Khalil is there in person. He is wearing a Navy jumpsuit. He's holding a string of prayer beads. And while Judge Coleman's mostly calm during the hearing, she focused again on keeping the parties from interrupting each other while asserting that she was focusing on just one issue, this one narrow jurisdictional issue that she said whether Khalil could be removed from the United States under the law. She said, I'm going to hear from the parties on removability, and that's it. And that's an important point. She is almost certainly not wrong about that. She could have arguably entertained broader issues, but she is affirming that as an immigration judge, she doesn't have the authority to go beyond that, declining to allow Khalil's lawyers to address their other requests, including to delay the hearing so she could review the evidence. She also would not allow Homeland Security Department to introduce new accusations against Khalil during the hearing, a very, very narrow, probably appropriate view of what her role is. Now, when Judge Coleman's issued a ruling, there were plainly responses, and Mr. Khalil himself spoke up at the time, expressing his great dismay about what was going on here. This is not, and this is the secondary, very important point about this, not a part of the headlines that you're reading on a regular basis. It's not over. This fight, plainly, as Mr. Khalil's lawyers have indicated, continues. Even though the judge has made her narrow ruling as an immigration judge, this case now moves on to what is known as the relief stage. What happens next? The relief stage. And that's the case where lawyers are able to argue his right to stay in the country. She's made this finding about deportability, basically upon the fairly narrow, but founded upon this notion that the Secretary of State's determination carries some weight here. Now the question is, what's the relief based upon the fact that she's found deportability, based upon Marco Rubio's, frankly, unadorned statement about what he did or did not do? Lawyers now able to argue for his right to stay in this country. That will happen next. So he is not going to be deported right away. If they lose, they can appeal. Where do they appeal? They go to an immigration board. This is all inside this process. And then, indeed, they can go to a federal court as well. So there's a lot of process here. And although Mr. Khalil plainly lost this first round, again, the judge finding very narrowly that she's got no jurisdiction to go beyond what she said and what she did. But there is another day for him. That includes, right, this secondary portion, the secondary stage, the relief stage, and that's determining whether or not he's got a right to stay in this country. There will be more evidentiary presentations about that. And if they lose there, again, they go to an immigration board. That's another administrative level. And then finally can appeal all of this to a federal court. And those are the courts that we've been talking about at great length here on our broadcast that have been entertaining these issues about whether or not deportability should happen, whether these immigrants have rights, due process rights, all those kinds of things. That is significant. And that is what is happening now in that particular case. Those legal hurdles to the government sending Mr. Khalil outside of the nation still remain. Broader challenges still coming up. The department has met its burden, Judge Coleman said, to establish removability by clear and convincing evidence. That is all that she has found up to this point. And so, all of this, again, for another day. The headline itself, an important one, the immigration judge ruling that he can be deported, but other steps yet in process as we think about that going forward. All of that, once again, it's a part of the due process, right? And though The findings by the judge are perhaps the kinds of things that many Americans would look at and say, gosh, should a decision of an immigration judge should be premised only upon what the Secretary of State says, which is the basis for this removal petition in the first place? That's a part of the process. That's why legislation can and should be amended, should be approved by the Congress if you feel that that process is not proper. That very same legislation also gives Mr. Khalil more opportunities to argue about the actual removal than an immigration board, than a federal district court, and argue in appeals court as well. Lots more, many more things to happen before this decision by this administrative judge, this immigration judge in Louisiana, has impacts beyond the decision that she has just now rendered. We know as well that the United States Supreme Court in recent times has entertained lots of oral arguments, and we began last week by talking about many of those that are on its docket recently in a number of different areas. It is important that we continue to think about what those cases are all about. One of them having to do with the Clean Air Act. In this case, the Supreme Court, in a recent case, in the oral argument before it a couple of weeks ago, appears poised to keep at least some Clean Air Act disputes. This is a legislation, once again, that is passed by the Congress many years ago, establishing the EPA's authority to regulate emissions, much in the news again today, to keep some of those Clean Air Act disputes in federal courts outside the District of Columbia, preventing what at least one justice described in the context of this particular case. It's called Oklahoma versus Environmental Protection Agency, was argued on Tuesday, the 25th of March, preventing what at least one judge described as home court advantage for the Environmental Protection Agency. Justices actually heard a pair of cases that day about whether certain Clean Air Act disputes should be heard in federal court in D.C., which is, of course, where the agency is, or whether they should be heard in various federal regions around the nation. The case heard by the court was about the proper venue, the proper place in which these cases should be heard for the EPA's determinations on what are called biofuel blending requirements for oil refineries. That's the underlying predicate upon which these cases have gone into federal court. The question is, should they remain exclusively in the District of Columbia, or should they be prosecuted? Should they be litigated, defended against in other areas of the country? EPA has recently denied exemptions for a slate of these oil refineries, and they have come in and said, we're not only opposing those fines, but also saying we should have the right to litigate these cases in places beyond the federal district court in Washington, D.C. It appears that the justices are in agreement with the petitioners there. The conservative majority seemed inclined to have those disputes heard in the regional circuit courts around the country. Judge Gorsuch saying, you're asking us to change historical practice pretty radically. He told the government lawyers at one point who were arguing again for the opposite view. Meanwhile, Samuel Alito pushed back on arguments that the EPA should get some deference under the law. He said, isn't it very odd to say that the court, in deciding whether there's venue in one place or the other, should defer to the view of one of these parties who are contesting the right to get home court advantage? So we'll see what happens in that particular case. Again, anticipating a decision probably coming up in June, maybe July of this year. The case, actually a couple of cases here, Oklahoma versus EPA, and another case as well, invoking and implicating these issues. The other one, Environmental Protection Agency versus Calumet Shreveport Refining, raising this issue about where these cases should be litigated, just in D.C. or in other district and circuit courts around the country. Second case, also on the 26th of March, having to do with the Federal Communications Commission and its determination under something called the Universal Service Fund. The Supreme Court once again taking up an important issue having to do with the authority of the FCC. When we come back, I'll tell you more about what that case was all about, what the Supreme Court seemed to be doing, and the importance of it.
This is Amicus Amicus, a law review. My name is Jim Santel. We are spending our 2-hour time with you this weekend talking again about the courts, a major focus of our routine discussions, and including the Supreme Court getting involved more and more in these major cases involving the president's executive orders and then on its regular non-emergency docket. Among the 64 cases that it has been addressing routinely, we've gotten some decisions in some cases, many more coming up in May, June, maybe even July of this year. Supreme Court entertaining a couple of weeks ago many cases and oral arguments, got more oral arguments scheduled for the coming weeks. One of those, a case called Federal Communications Commission versus Consumers Research. And it involves the FCC, the Federal Communications Commission, and indeed a thing called the non-delegation doctrine. Recall well that in the last term, the Supreme Court drop-kicked things called the deference, called Chevron deference, 40 years of deference to expertise and reliability inside agencies, getting rid of that concept. Well, here's another case where another concept called the non-delegation doctrine may be on the docket, is on the docket as well of the Supreme Court for review. What happens in this particular case? Well, the Supreme Court in this case leaning toward upholding a $9 billion subsidy program that funds phone and internet service in rural areas. That's a good thing, right? And schools also during these oral arguments recently before the Supreme Court. The dispute about whether or not that $9 billion subsidy to bring internet to these rural areas, these impoverished areas in our nation, also schools in desperate need of this kind of educational support. The case also gives the justices this opportunity to examine the so-called non-delegation doctrine. That's a doctrine that's been around for a long period of time, has not been invoked for many, many years, prevents Congress from delegating its legislative authority to the executive branch. Again, premised upon this notion that agencies, this deep, dark administrative state, should not be given all the authority that it seemingly has, including the FCC. The Supreme Court has not struck down a statute under this doctrine in 90 years. But anti-regulatory groups, including the ones who are advocating in this case, had hoped that the Supreme Court would revitalize it now by agreeing that Congress, here in this case, had given the FCC way too much authority in administering these subsidy programs called the Universal Service Funds. At the arguments, however, a majority of the 9 justices seemed sympathetic toward the government's defense of this particular arrangement, the $9 billion in subsidies, and also to not overturning its decisions about not supporting this non-delegation doctrine, which has been its tradition for 90 years or so. Justice Elena Kagan saying, what you're saying is that we should read this statute as expansively as possible to give the agency as much power as it could possibly be viewed as giving, all in order to, in the end, blow the statute up, she says to those people who are arguing against what the FCC has done. And I think that's just not the right way to think about the interpretation of regulatory statutes. That indicating, again, Elena Kagan, as do her other justices on the bench that day a couple of weeks ago, that likely they're going to support this particular decision by the FCC and not overturn 90 years of tradition in which they have said, yes, indeed, Congress has delegated to many agencies, including here, the FCC, some of its authority. We know that this continues to be a regular battle in front of the Supreme Court and other courts of our land, focusing upon the authority of the agencies and the expertise inside them to make decisions that make our country go, that necessarily courts need to rely upon. We know in this past term, again, under the doctrine of Chevron deference, which is now discarded, the Supreme Court dealt a blow to that concept that agencies are entitled to some deference when it comes to judicial action. We'll see whether the non-delegation doctrine suffers the same fate. Probably not. But again, a lot coming up in May and June of this year. And a final commentary here in our last moments of this last segment. And that goes back to the White House once again, issuing more executive orders. These of special moment and of special consequence, catastrophic, ultimately, not only for the reasons why our callers have called in today, opening up doors to further inappropriate conduct. The president just this past week issuing memorandums
identifying perceived adversaries and past foes of his for criminal scrutiny, and erasing and leaping over and violating the long-standing separation of powers that's existed between the executive branch and the White House and the Oval Office and the Office of the Attorney General. For years, a president has not been able to call up the Attorney General and say, I want this person investigated. The president can do an awful lot of things with respect to encouraging specific kinds of prosecutions: antitrust, environment, tax, national security, civil litigation, immigration litigation, all kinds of broad issues, but not targeting specific people. That has not been the tradition. That has not been the practice of our nation under Republican and Democratic administrations alike, violated just this past week by our president when he identified Christopher Krebs, former cybersecurity expert who contradicted claims by Donald Trump that he lost the 2020 election because of electronic voting machines. Our president telling our Attorney General just this past week to review Krebs' actions to determine whether he had provided classified information, whether he had violated the criminal law under the Espionage Act. Also, another memorandum with respect to a fellow named Miles Taylor, who was a former Homeland Security official. He was the author of an anonymous 2018 New York Times opinion that talked about the folks inside the departments of, across the board, Department of Justice, Homeland Security, who are pushing back on what he described as the president's dangerous impulses. The president directing Homeland Security to look at that fellow as well, Taylor, to determine whether he has violated the Espionage Act and committed treason, which of course is a crime punishable by death, indicating once again that this president, consistent with one of our callers said earlier, is now identifying particular people, these in his first term, who he continues to view as his foe, as the people who are in opposition to him, and referring them by name to agencies, including the Department of Justice, for possible criminal prosecution. Pam Bondi has said she's got no problem with that by abandoning the longstanding tradition that says that she is not going to, an Attorney General should not be engaging in those kinds of communications. That barrier that has existed before, she is going to likewise bring that down. This past week, we've seen exactly what happened here. And it raises a number of issues, not only with respect to the abandonment of that tradition, but also what could happen down the road to others also targeted by this president and presented for investigation. The investigation itself is in fact the punishment. We'll talk more about that and other issues related to the rule of law here on Amicus, a Law Review in future editions. Join us for those broadcasts. For now, have a good weekend, everybody.
The national news cycle never stops, but it can be hard to find news about your local community. Civic Media is dedicated to providing quality local and state news coverage across Wisconsin. With the Civic Media app, you can get notifications about local stories that matter to you and your community. Find the free Civic Media app in your phone's app store and choose notifications from the menu to tell us what kind of news you want to hear about.